that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Hey, everybody, welcome in.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
Snippets.
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected. But
All right.
the state redacted out the beginning, the end discussions of Tyree. That would be hearsay.
We're still waiting
Right.
for another jury member to show up, too.
So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
The nonchalant
There's
snippets.
connectors between all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes.
But it's just more or less what was played in during testimony.
You're late for jury duty.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know, it's something you could have cross-examined her
Mel, I
on, but
did.
now it's probably too late.
5-minute delay instead of 30.
If you wanted clarification on that. But the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the
Black Widow, you
instructions.
really
So
didn't
either
miss
side
shit,
can
to
point
be
that out
honest.
to the jury that
Hopefully they have a
it's
verdict today.
redacted.
And sorry for being late, guys.
Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect
Shut
the
up,
record that it
Lori.
was the full
Shut up,
interview.
Lori.
So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
No.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the exact
My advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes, Your Honor.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the detective at the end about Kylie and victim services. It doesn't include any of that. She's sitting in a room for I don't know how long while Kylie's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct?
I
They
cannot.
Whatever
have
was-
access to that.
Whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview, and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20, is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that.
Dumb. Dumb. Shut up.
Anything else?
That's it.
All right. We're
Oh, she's audibly
getting
frustrated.
the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions.
They're still not there, y'all. The jurors still aren't there. Smoke break. The jury is still not there. So how long are we waiting? I don't know. Smoke them if you got them, I guess. Yeah, she's an idiot. She's an idiot. So what do you guys think in this poll? Let's see. 1 day, 80%, 2 days, 17, 3 days, 2, and more than 4 days, 0. I think it'll be today. I don't know why, but I just think it's going to be today. Hey, Striker. Hey, OU812. Cooked. Pearl Strand Lori. No means no. She's like, that's it. She's not used to not getting her way. She's still getting used to that concept. 15 minutes, Nicole G. Sweet. Thank you. Coming up, closing arguments and verdict watch. We're here for it, babies. We are here for it. It's smoke break. Let's have a smoke and a Coke and a smile and let's shut the fuck up. I'm just kidding. I'm in one hell of a mood. Nate said they were told to arrive at 11. Oh, so they're not late. They're supposed to be there at 2. 11, 12, 1, 2. That's 3 hours, right? I think it'll be quick too, Tato. Happy Monday, Potato. I miss you guys. Jay, I forgot to ask if you were able to spend the day with your littles like you wanted. Yes. I drove home with you guys yesterday. We went down to my son's house and I drove home the hour and a half drive home on Every Day with Jay. And you guys made my ride go quicker. Cassie, she's totally clueless. And then think about the next one. Then there's the Brandon trial. I hope you guys all had a great Easter, by the way. It's like Easter hit and it's immediately hot as hell down here. No, it's hot. It was beautiful yesterday, though. We had a beautiful day. It was like 86, sunny, breezy. Oh, really, Cassie? That's funny that he watches. Happy Monday to you. I haven't seen Robot yet. Lori objected because it wasn't the full interview. It was overruled, so only the parts. You want to call in, Ryan? Yeah, hold on. Hold the phone. We can do that right quick. He does, Cassie? That's so sweet. That really is nice. Thank you for telling me that. All right, go ahead and call in, Ryan. 727-755-6001. I almost said my cell number. 727-755-6001, Ryan. You know the number. You know the number. Brandon is there today, according to Nate Eaton. Sarah, are you going to Stern's thing? Are you going to call in when you go to Stern's? Stern's. Let me know what day you're going, Sarah. We got Stearns this week, too, in court. His trial is fixing to start soon. Kathleen, that's so nice. Here we go.
Call from
Ryan Apple Sample.
Hey, Ryan. Can you hear me?
Hey, so first of all, I'm not there this. Yeah, I can hear you. Can you hear me?
Yeah, I can.
Okay. So first of all, I'm not there this morning. I had to work. I couldn't get off.
Oh, bummer.
I will say this: our traffic is not that bad. I came across from the other side of town, and I was getting there before the jurors. So I don't know how and why this person takes forever, but
Isn't it funny though? I would be like early if I had jury duty. I would be scared to be late. Like, and I'm a person that's always fucking late. I'm that person.
No. So when I was on a jury 2 years ago in this courtroom, like this courthouse, we were all on time. Like, we made a pact that whoever was late had to buy coffee the next day for everybody. So we were like, okay, we're all going to be on time.
Yeah, that's a good pact to make, because when one is like the single one that's always late.
Right. And you don't know who's late every time because they don't bring the jury in until everybody's there and ready.
Right. Like when we watched Crumbly, remember she would bring like jurors in and be like asking them questions on camera. Like we heard it all. This, we don't ever hear him talking to the jury.
Mm-mm. No, and I think that this one, depending on how quick Lori is on closing arguments, I think we'll have it today, because you guys got to realize we close at 4 and the latest they can have it open is 5, if I remember right. For this is the new courthouse. For people that are from Arizona, this is in the new courthouse. So it's the one that's further south. But
I mean, it
they
does seem like
close
a busy area.
it is. It's a very busy area. But even if it were, if you like, the parking structure is literally across the street, and it's only a 4-lane traffic street. The parking structure is
Well,
literally.
someone said they're not supposed to be there until 2 Eastern. So technically they're not late. But it sounds like the judge was ready to go. Like,
right. But you would think that they would get, because you got to go in through the metal detector part, and then you got to go up to the 5th floor, and that doesn't take long. But I mean, I was there at 6:30 the day I had to be there.
I know you were there freaking early. Yeah, you had to.
And I was 5th in line when I was on last Monday. But I mean, either way, she's life in prison, no parole. But we do want justice for Charles' family and for Charles. But I'm hoping this doesn't get delayed another day.
No, I hope they'll come back with a jury today. With a verdict today. But I don't know. Based on what they were given, I feel like it's weird to me, I guess, knowing that I know everything and that everything wasn't brought in. It bothered me at Delphi too, because I knew more and it wasn't brought in.
Well, and the body cam. So I messaged I have a degree in criminal justice. I have an actual degree in criminal justice. I messaged one of my old professors and I was like, hey, is this hearsay? Because I was asking about the body cam from Charles and Chandler PD when he was trying to get her in with CBI, which is our mental health facility. It's Community Bridges. Mm-hmm. It's one of our mental health facilities. And she said technically it can be because he can't be cross-examined.
Well, she's mad now.
Oh, she has the whole world to get glad in, like my grandmother always said. She has the whole world to get glad. But I think
what's
we'll
your
either have
prediction
it.
though, Ryan? What's your prediction for today?
I think 2 hours we'll have a verdict. But if it runs into the time constraint of the ability of the court being open, that's where we might run into tomorrow.
I wonder if they have a time limit on the closings.
Well, prosecuting said an hour and a half that she believes hers is.
Look it just said this video is unavailable.
Are you on court? Yeah, you're on court TV.
Uh-huh.
See, and there's only one like I told you before, there's only one.
They made it private.
Yeah. I don't know. There might be a delay from the juror that isn't here. But I got to get going. Y'all have a great day.
All right. See you, Ryan.
Take
have a
care.
good
Bye-bye.
day. Now, isn't that weird that they put that on private? Unless they're going to start a new stream. Let's see what Eaton... Nope. Eaton's there. That is weird. Court TV is wild. They're coming back in. They're muted still. Why would it go private? Imagine if the jury turns this around in an hour. I know, that'd be crazy. You think they have enough evidence to convict, but you don't think it'll be today, Meg? Court TV started it too early. I thought they were the only camera in there. I thought they were the pool camera. I think that's weird. Court TV. Let's go back to him and see. Jesus Christ, Court TV. God dang. No, they don't even have an event.
And I'm praying to God, please don't.
They only have Karen Reed upcoming. I don't know. Anybody can watch that trial. That lady's face is just such... Ugh. I guess we'll just stay on East Idaho News. Why would they be hitting her with the zap? Oh, he's not live no more. Oh, yeah, he is.
Your desk this morning.
Here we go. Court TV is not even live. That is so weird.
Last week, let me just pull up that email.
No eating in the court, please.
They're behind Court TV? I don't think so.
Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized
It's not a half
standard
hour.
number
It's not a half hour delay though. He only made it a 5 hour or 5 minute.
as well.
Is
Have you had a
this-
chance to review the latest?
Are we starting over like we did this morning? We've already seen this. Oh, Angie, she looks like a total bitch. Are we watching what we already saw? What already played on Court TV? They went live too early. Like, how do you make that mistake? You're Court TV. You have one motherfucking job. How do you fuck that up? So this is a repeat, and then we're going to be waiting again? What a cluster, man. Who's EIN? Reload. EIN took out Court TV. Who's that? East Idaho News took them out. Oh, it's 5 minutes only for the verdict. I thought it was for closing. Okay, got you. So we're rewatching right now. I'm telling you what. There's nothing like a boring ass trial played times 2. Hey, Robat. Nice to see you. Why am I so nervous considering she's never leaving prison? I guess I just really want to see Charles get justice. Yeah, me too. What's the point of the delay? I don't know. I guess in case something happens, it's not on live TV, they can stop their cameras.
Any other record you want to make on mere presence?
Oh, yeah.
All right, has the defendant had a chance to
hold on.
review the final instructions?
We have to
Yes, Your Honor.
celebrate.
Any additions or corrections?
It's Robat's birthday today. Happy birthday, Robat. We love you so much and hope you have the best birthday ever.
Go, shorty, it's your birthday.
Happy birthday, Robat. It's a good day today. I love birthdays. She's 50. Happy birthday, girl.
My staff emailed the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm to the next man.
Anything else?
The presence of an accomplice.
Okay.
That should be it.
And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Hi, Cheryl.
Potentially testimony from the next defendant.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have 2 issues I'd like to bring up real quick.
Go ahead.
Yeah, this is a replay.
The jury process of the jury alternate selection. Can you
I
tell
didn't
me
hear
what
it,
that
but-
process is going to be today?
It's literally drawing 2 numbers out of randomly out of a container.
Okay.
The process.
And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate.
Reloaded
Does
is
that
an
make
angel
sense?
wing. I have an
Yes.
angel.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes
we've
long.
already heard this.
Remind me what's 286 is, whose interview?
My whole interview.
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court.
Okay, we're going to mute that because we've already heard it. And we are going to wish Morgan a very happy Sweet 16. Angie, how exciting. Sweet 16. Happy 16th, Morgan.
Go, shorty, it's your birthday.
Had a lot of birthdays over here in the last 2 days. Happy birthday, guys. Hey, Cole. How's my favorite viewer today? I know. She thinks she's so damn
in
on top
during
of everything.
testimony. Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late.
Whoops.
If you wanted clarification on that. But the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Hey, country
Your full
girl.
interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
counsel checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there a,
Little miss, little miss.
sometimes
little
they
miss,
enter
can't
in
be
the full
wrong.
interview for appeal purposes only, but that's not the one that
Lori.
actually gets shown to the jury.
Lori's little
Was
miss
there
can't be wrong.
was that the case?
Was not for appellate purposes, Your Honor.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Kylie, does not include that. She talks to the.
I think it's so funny they got her blazers that are pleated to go around her.
Services. It doesn't
shock
include
belt.
any of that. She's sitting in a room for, I don't know how long.
That's awesome, Robat. A 16 Pro Max. That's like an iPad mini.
Okay. So the state's closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Ty Lee
Aw,
said
thanks,
or did or
Sophia.
didn't happen, the hearsay parts
She said, "Happy birthday,
were,
Robat."
the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20, is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that.
Quit arguing with the judge, Lori.
Anything else?
That's it.
All right. We're
That was my
getting
favorite
the
part.
sufficient number.
That's it.
I love hearing her frustrated.
Anything else?
That's it.
All right. Anything else?
That's it.
All right. We're getting the sufficient number of
I love hearing her frustrated, man. I don't know. Call me evil. I love hearing her frustrated and not getting her way. That's it. I haven't heard more sighs since Tara Linskin. I need to clip that. Clip it real good. Clip it Crockett style. Now I want you to clip this. Clip this real good. Let's see what's going on with Court TV now. She told them to clip it. Clip it real good. Nope. Still nothing. Still nothing. Is this it for the day? No. No. So the jury they were waiting for the jury to get there to go over, I think, jury instructions and closing arguments, and then they're going to go to verdict watch. Tato. That woman. Jay, you are too damn old. Ooh, let's see what 8-Ball says, truck you. I can't help but think Lori's going to pull a fast one when the jury comes in. What do you mean as far as what? What do you think she could do?
What you are witnessing is real. The participants are not actors.
Okay, they're live. Oh, here we are. They're back. True After Dark says, that was so weird, Court TV. I sent you a message. Court TV says, hey, Courties. They're trying to play it off. Let's get rid of their chat. There we go. They act like they didn't do anything wrong. Hey, Courties. They have names for their chatters now on Court TV. Courties. Who? No, I think she said she was resting, right? Oh, you think that maybe she won't? Oh, Lord. Get your girls to cut a clip. Clip this real good. Court TV being put on timeout is the starting of a Black Mirror episode. Is it really? That show is beyond mind fucking. Is it really though? That's weird. What do you mean being put on timeout? How does it go, Reload? Jury is on 15-minute delay, they say. But when did I don't know what you mean jury's on a delay, but what time was this officially supposed to start? Does anybody know? Cut a clip. I thought the official time was 2. And it's weird, right? Because we're looking at the emblem. Are we now on a delay? Where are we? Like, where do we stand? Court TV has us here. Oh, I don't like it, Robat. It leaves me feeling weird. I don't like those kinds of shows. Let's go back to East Idaho. He's live with the same thing. So what in the actual F is going on? Are we now the delay camera? How long I mean, this is so fucking confusing. Sorry to bitch. Hey, John Gone Girl. Jury is in. Stream is 15-minute delay. 15 or 30? When did it become a 15-minute delay? It's been 30 throughout, and then he approved a 5-minute delay for the verdict reading. So is it 30 minutes or 15? They began with jurors at 11 a.m. Pacific time. Okay, so we still have 10 minutes because it's a 30. Yeah, I don't like that, Robat. It's too much. And people binge that show. So it's a 30-minute delay. We probably have 10 more minutes. It seems like we're waiting longer in this trial for anything. You know what I mean? Like we're waiting more than anything. The sad thing is the state couldn't even present a full case because they didn't want to show how badly the police screwed up. Is that why? Oh my God, Evelyn. Now you really got me confused. I think they couldn't let them know that the kids were killed, right? I think they're going to take an hour break. What? A break from what? They haven't even started. Why would they take an hour break? They just fucking got there. I'm really confused. I'm going to shut up. Just kidding. But I am confused. Maybe I should go to X and just read Nate's thing. That would be smart. Oh. Oh, he had to remind someone that eating is not allowed in the courtroom. Right here. Just saw Brandon Boudreaux walk into a private room near the courtroom. Madison County Sheriff Ron Ball is also here from Rexburg. Here's the schedule for today. Video will be delayed 30 minutes, except the verdict. Monday, 10:30, court begins. 11 a.m., jury instructions. Noon, lunch. 1 p.m., closing arguments. Jury then deliberates. So they're not going to go to lunch until we're going to get an hour of court. And then they're going to go to lunch, which is completely fucking stupid. I mean, literally, they start court at 10:30. These people are going to be there for an hour and then they're going to go to lunch. Why wouldn't you do the jury instructions, do the closing arguments, and then let them eat lunch while they deliberate? This is so screwy. We are inside the courtroom now. Kay Woodcock, Jerry Vallow, and Susan Vallow are here. Trina Kay is at the prosecution table with her paralegal and Detective Nathan Duncan. Defense attorneys and Lori Vallow are not yet in the courtroom. Every seat is full, and several members of the public were turned away. No seats left. Defense advisory attorneys just walked in. Lori's investigator. Oh, we already watched that video. Da 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 da. Judge explains what an accomplice is, what aggravated assault means, and what act means. So he's giving the instructions now. Lori is following along with an instruction packet in front of her. Lori got a packet. And Trina K is also following along. Doesn't that seem like a waste of time to have them come in for an hour and then go, oh, we're going to break for lunch? So here you go. This is the schedule. We've got roughly 6 minutes before I think we're brought back in. They're going to take a whole ass hour lunch, too. Seems kind of stupid to me, but what do I know? What do I know at this point? Yeah, I mean, I don't know why it makes you nervous, though, because she ain't going anywhere. I mean, I get the whole justice thing because MJ is for justice. I get it. I'm just kidding. But no, I get it. But I mean, it's not the end of the world if she's not convicted. I mean, it does give her a victory, but at the end of the day, she's still getting her just desserts. I would be annoyed as a juror. I would want to hurry and get shit done and go home. Me too. Me too. Yes, we are live. We're waiting 6 minutes, 5 minutes until we're brought back into the court for the jury instructions. What's up, J-Lo? J-Lo. State didn't want their closing to be broken up by a big break. I mean, I get that. I do get that. Like, you don't want them to hear the state and then go for an hour lunch and then hear Lori. So I do understand that. But it's like they only have been there for an hour. And the question is there a time frame on how long they can do their closings? Hey, Betsy. She's still going to die in prison without this case. Yes, she is. Yeah, she's not going nowhere. Hey, I'll be right back. I've got to go grab my phone real fast. I left it in the living room. Hold on. BRB. Okay. I did jury duty for a drunk on a bike once. Total waste of my 3 days. That's a weird one. Evelyn says, if I was a juror and I saw the Charles police cam after the fact, I'd be so annoyed. Yeah, me too. I mean, I kind of felt like that after Delphi, too. Like, if I found out after that there was like all this other like child pee and the meetups, you know, the Snapchats and all that stuff, I would have felt duped as well. Hey, Fire. Oh, Megan, I believe Trina said I believe Trina said about an hour or so for the prosecution, and Lori said less than that plus the rebuttal. Thanks. I didn't hear that said. I would love for Charles' family to win this. He asked how much. Okay. You haven't missed much. Nope. You haven't missed anything. Slim has never been called for jury duty, almost 52. Me either. And I'm 50. 51. I'll be 52 this year? Oh my gosh. You've been called 4 times, Betsy? It's 88 outside right now. Feels like 88. Hold on, guys. I'll be right back.
All right, that's fine. All right, we're back on the record. State of Arizona versus Daybell, CR 2021-001704. The parties are present. The jury is not present. We'll bring in the jury.
All right, here we go, guys. We got an hour, and then we'll... Oh, my God. What just happened? I couldn't hear what he said. Let me know in chat what he said. I missed it. I thought we were starting.
All right, please be seated. The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
Oh, whoops. All right, enjoy the stream, guys.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions. Are we one? Oh, nope, we got it. Okay. The jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it, in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1. Solicits or commands another person to commit the offense, or 2. Aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3. Provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1. Causing serious physical injury to another person, or 2. Using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1. Force which is used with the purpose of causing death or serious physical injury, or 2. Force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1. Make sure every member of the jury is present during all discussions and deliberations. 2. Make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3. All jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4. All members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5. If you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6. If the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7. When you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Largo Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019, as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
All right, so we have an hour for lunch, guys. I'm going to go ahead and do a little bit of yard work while this is going on, and I will be back here in an hour. I'm going to flip you guys over to the recess. We'll be back at 4 o'clock, 4:30 Eastern.
I'll have the parties
Because
back
we
in
have
the
the
courtroom
half
at
hour,
around
right? So we'll be back in an hour and a half.
12:40-ish.
4:30.
And my staff will
I'll
be
put
here
this
if
in
you
the
need any
chat. Pin
exhibits
it.
that you anticipate needing for
Everybody
closing
knows.
arguments, or we want to double
Because
check.
that's right, right? Because we
any
give the
media
half
that you might
hour and
need
then we
is
have the hour of
working
lunch.
at that time.
So court will resume
All right, anything else from the state?
at 4.
Defense?
Your Honor, can I move for Exhibit
30
20 to be
PM.
admitted for appellate purposes?
Eastern Standard Time
Is that your full interview?
Yes.
for closing.
Any objection? All right, Exhibit 20 would be admitted for appeal purposes. It won't be
All right, there's
given
that.
to the jury during deliberations. Are you sure it's 20? It's for exhibit.
Pin it.
It is.
Defense 20.
No, it's defense 20.
It's defense
Well,
proposed
it's got
20.
numbered.
Numbered on different ways.
Oh,
It's going to be 200 and something.
Okay, there you go.
yeah. Give me
Oh,
a
I
second.
guess
I'll figure that out.
they're still talking? Hang on. God, I'm so out
And
of it.
should we put it on a CD?
We'll keep it on then until.
Anywhere from 256 to 272. You'll have to figure out which one it is. But we can clarify that. Might have to look at the actual exhibits to determine which one it is.
Yeah.
Ladies and gentlemen, we're going to ask that you take all of your belongings with you for lunch.
Yep, they're there.
Anything else?
That's all, Your Honor.
So,
Remind me to clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the exhibits.
All right, we are officially on lunch. Hey, Pearl Strand. If you guys could hit that like button if you're heading out and coming back for the break time. And I will see you guys in about an hour and a half.
This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, she sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later, on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, "If something happens to Charles, I'm going to have to go to the police." Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, "You probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money." Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case, and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. They talk for 20 minutes, and Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming, and we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message, this one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad, 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? A gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is, in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car, and then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves, as Charles is laying dying or dead on the floor. 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham.
You see on her records that she, again, calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Fork Peaks. And when asked about it, the defendant entirely handed over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay. So I don't know how I want to put that. Okay. All right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages? And Exhibit 230. It would be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, And she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad, the affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly Time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th. Big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those, and he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants, this is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. But what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with, that she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more, though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs, and she said pretty much after that the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say.
Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
So it wasn't just you in a private conversation?
Correct.
She was open about it?
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words.
From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
we believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. The defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. This is where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day, and you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles.
Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once.
Yes.
Can you describe for us part of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so, as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th. Again, we have Melanie who is talking to her and saying that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him. And Nephi was told to kill Laban.
Who was he told by?
The spirit, or, yeah, God.
So God was using a Holy Spirit to tell him to kill Laban? And
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is, from Detective Duncan and from Adam, that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that, in fact, we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back, before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and that he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. 1, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30. Pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around as he's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote, she is the one who on the 9th said, we will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him. And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm. No questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th, in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, just because you don't have someone who says, I heard them say, we shall conspire, you can infer that from the conduct. The conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him, or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this, and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclen, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car? She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclen that Tylee comes out with this fact. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ, and so he put it in the car, in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, giving me my phone, and I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for, you know? He's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened, how did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and...
He comes back in, I haven't given his phone, he was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there and he was screaming at me. And I was kind of walking towards around the house with it so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. He got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But what we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
Field with your brother.
Yeah.
What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Right, left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside, and
what happened?
then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me at the bat, yelling at me to give him his phone still, because I had it in my hand. It was all really quickly. And then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards. In one arm.
Like he was swinging it backwards? He would have done like
he would have swung it backwards at me, not frontwards.
Okay.
So Lori Vallow tells Detective Enclan that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, the arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down? Out? Somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen, down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Coons told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun within Charles, 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it. Someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who've come here and talked to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day, where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence, and you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. It's Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have 1 kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son Colby isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We've talked about a few things, but one of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. Oops. If this will play. When she was questioning Detective Enclam, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
You live here though, now that you're not in Santana, this is your home?
Right,
Gotcha.
right.
Okay.
We just moved in.
Gotcha. How long have you guys lived here?
I'm sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
Are you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, the projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand, and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex, or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in 15 minutes.
Well, what did you guys think? Did you guys think that she did a good job? Do you think she summed it up good? Lori's is in 15 minutes. I'm going to end this poll. Oh, no, I'll leave the poll. Never mind. I think Lori is so unlikable it won't matter. But do you think that I'm here for Lori's too. I mean, I didn't listen to it all because it was so fucking long. I feel like it was too long. And to be honest, I was kind of listening in and out of something else. But I'm here for Lori's closing for sure. Because this will be storytelling time. She's not going to be asking the dumb questions. I just hope that there's justice for Charles. You know what I mean? I hope that they've convinced the jury. So our poll, how long will it take for them to come to a verdict? 1 day, 78% of you. 2 days, 17%. 3 days, 2%. And more than 4 days, 3%. Kalina, you're so funny. I think she laid out the evidence clearly with what was presented in testimony. Hey, Birdie. Birdie. I haven't seen you in a while, Birdie girl. I thought he said 15-minute break. But, it's going to be 30 minutes because of the fucking, because of the 15-minute, or is it going to, wait, hold on. If they're taking a 15-minute break, does that mean we're gone for 45 minutes? Is that how it's going to work? Is it going to be 45 minutes or is it going to be the true 15-minute break? I know Streamlabs is kind of a smartass sometimes. 30 minutes for the verdict. Got you. But I'm asking about this break. Is it going to be a delay again? Or are we just like paused for 15 minutes in real time? I'm so confused by this delay. I need just real time stuff. This delay shit. I just hope that she didn't lose the jury because I hope they were, attentive. It's just 15 minutes. Okay. So, okay. So, real time, they're actually back and Lori's giving her thing. Okay, so let's go read Nate Eaton so we can get. Now, this is going to be, what do you call it? Spoiler alert. Nate Eaton lunch. Okay. Nate Eaton. Here he is. Okay, 20 minutes ago, they were back in and seated. Back in the courtroom 20 minutes ago, parties are seated and jurors are in their chairs. Lori Vallow Daybell will now present her opening argument. Lori approaches the podium The state of Arizona has a 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit first degree premeditated murder of my husband, Charles Vallow. Then she goes on, let's see. We learned, oh my God, this is what she's using. We learned. Look at what we learned in this trial. We learned a shooting occurred. We learned that Alex came out of the house. We learned that Tylee asked for her medication. We learned Alex was taken to the police department. We learned me and my daughter were taken to the police department. Lori says, we learned that Tylee, Alex, and Lori were taken back to the house in a police van. We learned in this trial that we did as directed. She's going to be annoyed. Lori asks why the state didn't show all the evidence. Trina objects. Judge, annoyed, says again, sustained. The jury can only consider what was admitted into evidence. Oh, the judge is getting annoyed with the bitch. Lori says Chandler police were ineffective. They did not swab their hands. Lori says the 2-minute period in the house changed their lives forever. Lori was shocked about the insurance policy, but she was not angry. Da 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 da. She's still going. The defendant wants you to pretend. Okay, so maybe it's 20 minutes long. Lori finishes and walks away. Okay, so yeah, it's about 15, 20 minutes that it's going to last. And then the prosecution gets their rebuttal. Hey, Shell, good to see you. Oh, yeah, it's going to be a shit show. Hey, Newfie. Everybody, welcome in, welcome in. We're just minutes away from Lori's closing argument. Hey, Pines. You have learned today that you should hit the like button. Hey, Sarah, Sarah. Actually, my dinner just arrived. I got myself a Jimmy John's tonight. Oh, shit, Alabama mama. I hope Granny's not mad at me. I really do. Actually, I'm going to text her right now. Hold on. I'm going to text her. Hang on. She's not mad at me. I just had to make sure she wasn't mad at me. Alabama. No, she's not mad at me at all. Pines, when you text her, let her know I emailed her about damages language. Okay, I'll let her know. I just feel so much better that I got that out. Okay, I let her know. Not that, Tammy. You were... Wait, is Culk's here? Culkin! Shane! Oh my gosh, where have you been? Okay, I'm coming on camera for Shane. Shane, where have you been? Shane, I've been seeing articles about your family lately. We need to talk. We need to talk. What's going on with you? No, she's not mad at all. Oh my God. It's so good to see you, Shane. I had to come on and say hi to you face to face, if you will. We really have missed you. It's good to see you. I've been worried about your ass. I have been worried about your ass. Are we still live? My TV's buffering. What's going on? No, it's cutting out on my end too, right? Are we still live? Yes, we must. We must. We must. We must increase our bust. It's really good. Thank you for coming in, Shane. I wish you could make more lives. We miss you so much. Yeah, I don't know why it buffered. I didn't get any notification on my side. I have no skipped frames or anything like that. I don't know what the fuck. You sure are. You're a fucking survivor. You may have to leave and come back if it's like bad quality. It's okay now. No, you haven't missed anything. We're just minutes away from Lori's closing arguments. Live, no face? Okay. Here I am. Here's my face. Hello, YouTube. Hello, YouTube. We're ready for Lori Vallow's closing argument. Can you put a 1 in chat if you're ready? Are you there, God? It's me, Margaret. Who else read that book to learn about your period? Raven, you were cracking me up. Here I am in all my glory. Wasn't this nutty chick already sentenced? And yes, I will definitely make more lives. He's been eating all the pink ice cream. She was sentenced for murder. Well, now she's got this trial for the conspiracy to commit first-degree murder against her ex-husband. And now she's got another one after this for her nephew or her niece's ex-husband. Conspiracy to commit murder. And she's repping herself. Hi, face. Nice to meet you. Hey, Locked and Loaded. Alabama. We had a wild afternoon, didn't we? Hello, God. It's me, Margaret. You guys are too much. You finish pink berry. That's what it is. Pink berry. I think pink berry's overrated. I think it's overrated. I'm calling it overrated. Who's Angela Brown? Hey, Nicole. Hey, Pearl. It's like Ramona Quimby, age 8. We all read it. We're back. Here we go, guys. Here's Vallow. She's going to get on the judge's nerves, FYI. Hey, Robot. No, we're on a delay, Buddha girl. So we're 30 minutes behind. Lori's, oh, Pearl Strand. Ouch. Because I've never had it. The pink berry. So Lori's thing is like 15, 20 minutes long, and then the prosecutor gets a rebuttal. I loved that book and movie. Thank you, Buck Cherry. That's nice of you to say. Oh, whoops. It's overrated deliciousness. Oh, Robat, it's a lot. It's a lot. I don't think you even want to catch up on it. Okay, here we go.
All right, please be seated. The jury is present.
Robat, we can cut you
The
up in
defendant
one
can
sentence.
proceed with her closing
Barbecue's
argument.
dirty. Period. Hey, Gyps. Come on, Miss Vallow.
Ladies and gentlemen of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction, under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms, where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inkland that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews
Object, Your Honor.
or let you listen to the 911 call.
Has to strike.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the 3 of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all 3 of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all 3 of our cars were inside the police tape. We were directed to return later in the afternoon when the scene was cleaned up. We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough was not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
I would ask to strike that and disregard.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained. The jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was, self-defense, and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
Testifying at this point? Not facts.
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Right. That's sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy. That's all.
All right, the state does have the burden, so I have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? that they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy.
You want a cough drop?
That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day,
when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14. Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God? I do. Thank you.
Izzy, drop those off. One, drop those off.
All right, so the jury.
I think he's going to come back and say they want to go home in a few minutes. But we'll stick through it to the end today, and then we will wait for verdict.
The jury's no longer present in the
I'll go live when the
courtroom.
verdict
I've passed
is
out
back.
proposed aggravation phase jury instructions. In the event that there is a verdict of guilt, the state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
There's a spelling mistake on page 3. That's as a 3 in it.
Got it. All right, we'll be at recess until we hear from the jury.
All right.
That's what I think too. Come back when it's go time. Yeah, I don't see any reason to sit around waiting for this verdict, to be honest. And I don't really think it's going to be long. But that's a wrap, guys. I'll see you guys when the verdict is in. Make sure that you have all notifications on YouTube for me. Culkin says, give us a stream. Culkin, are you subbed up to my other channel? because I've been calling out a bunch of bullshit, lies, misinformation, and everything else over on that channel. And it's been busy because there's been a lot of it out there. And don't be a stranger. Exactly. All right, you guys, I'm going to wrap this up. Thank you so much for being here today. Make sure you hit that like button and let's roll our credits. We got some support today here on the channel. Thank you for watching J is for Justice. Until the next one, stay safe and I'll see you soon. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further?
Bring it all in.
And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click. It's real easy, man.